company's data is becoming more and more valuable, but data security is often approached by building a moat around the perimeter of the castle. For instance, by focusing on firewalls and intrusion detection systems. But often the threat is already inside the castle, that is, their own employees. A 2016 Verizon data breach investigation report found that 77% of data breaches are committed by internal sources, that is, employees. 34% of data theft committed by employees is for financial gain. And 49% of data theft that occurs from employees takes months before it has been detected. Employee data theft can lead to more than just the loss of critical information. It can also result in compliance failures and legal penalties. The opportunity cost of business being diverted to a competitor's business, damage to your organization's reputation and goodwill, and even the loss of the entire business. So what is the solution? Well, prevention is obviously better than cure. First, proper labeling. If a company does not take sufficient steps to treat its own confidential information as confidential, legal protection may be lost. This is especially important in respect of third parties. Second, insert non-disclosure provisions in your employment agreements. If a company has confidential information which is particularly sensitive, it should be clearly identified in the contract. Third, add a confidentiality policy to the employee handbook. Fourth, conduct exit interviews to remind departing employees of their ongoing obligations of confidence to your company. And fifth, invest in IT solutions that monitor your data and your employee behavior. Because it usually takes months before data theft has been detected, it's important to conduct regular data security audits and invest in software that will generate automated reports and notifications designed to alert you when something has happened that warrants your attention. For instance, setting an alert to receive an immediate notification anytime someone sends an email with the phrase like company list in it, or an unusual peak in USB activity on one of your business's devices. If you become aware of a data breach, it's critical that you move very, very quickly. This is because many of the available remedies for breaches of confidence, such as obtaining an injunction, delivery up, or an account of profits, are equitable in nature. The doctrine of laches, which is Latin for delay, is based on the maxim that equity aids the vigilant and not those who slumber on their rights. The application of this doctrine means that an equitable right may not be granted if there has been undue delay in asserting it. Often damages will not be an adequate remedy to a known data breach. The chances of mitigating the problems associated with a data breach will be significantly greater if you obtain an interim injunction, because this will restrain the defendant from using or disclosing the information by court order. The court may also order the defendant to swear an affidavit outlining everything they did with the information, so you will be in a position to identify the extent and cost of the breach. McCabe Curwood has extensive experience in advising with respect to data security and litigating breaches once they occur. If you want to ensure that your business is taking the right steps to protect your data, or have discovered that your data has already been compromised, please get in touch with us today.